welcome to this week's Asia Research Story. For those of you who don't know me, I'm Renee Jeffery. I'm a Professor of International Relations in the Griffith Asia Institute at Griffith University, and it's my pleasure to be hosting another great Asia Research Story. Before I do, I'd like to acknowledge the traditional owners of the various lands on which we're meeting, watching and participating in this event, and I pay my respects to their elders past, present and emerging. For those of us who are joining us live via Zoom today, welcome. It's great that you're able to join us this week. There'll be a short Q&A at the end of the session, so please submit your questions using the chat function. And don't feel like you have to wait right until the very end of the conversation before sending them. It would be really great if we had some questions ready to go when the Q&A session starts. And of course, we're using the Researching Asia Stories hashtag on Twitter, so please join the conversation on Twitter during the presentation, but then also afterwards for the rest of the day as we continue to talk about the ideas and the work of our guest today. For those who are listening or watching the recording, I hope you enjoy the conversation and that you're able to join us live at some point in the future. So I'm really excited to introduce this week's guest. I wasn't exaggerating when I wrote on Twitter earlier in the week that today's guest is one of the brightest rising stars of international law. I think she's a little bit embarrassed by that description, but I don't think it's an exaggeration. Dr. Emma Palmer is a lecturer in the Griffith Law School at Griffith University, which she joined in 2018. She has a Commerce Law degree, a Master of Laws and a PhD, all from the University of New South Wales. Emma's work focuses on international criminal law, human rights and humanitarian law, transitional justice, infrastructure, governance and regulation, gender and international law and legal systems in Southeast Asia. So welcome, Emma.
Thank you, Renee. It's a pleasure to be here. Thank you so much.
That's all right. So you've had a pretty exciting week. I know that I was very excited to get this in the post about half an hour ago. So just in the nick of time. There's something about seeing an actual physical copy of a book that you've written for the first time that's really, really very special. So I hope you're enjoying the experiences of having, the book, in its physical form for the first time.
Yeah, it's quite surreal, I have to say.
Yeah.
But exciting, yeah.
Love the cover. It's so evocative. Where did the cover image come from?
Yeah, so that was an exciting and interesting time. So the cover, I looked at a lot of different things. I was hesitant to have faces and people involved in the cover, but one of the kind of themes that comes up in a few of the interviews that I mentioned in the book is that of shelter and the idea that we have different conceptions and understandings of shelters. So I had that sort of theme, and I was also aware that in some forms of Buddhism in particular, the parasol has a particular symbolic meaning of a shelter from suffering potentially, and there's lots of different interpretations. So yeah, when I came across this very striking image of the parasols in Bagan in Myanmar, it just seemed to fit a lot of those things. And also, it's got all these different bright colours and diversity in it, and there's the contrast of the dark and the light, but also these gradations in between, which is what the book's really all about, is trying to shift away from very binary kind of approaches and look at a range of different voices and understandings. So yeah, it just ticked lots of those boxes.
Yeah, it absolutely does, and it's really striking. It just looks really, and it is unmistakably a Southeast Asian sort of image. So yeah, it's really great. So we're going to talk about what's inside the book in a bit. But before we do, I wanted to talk to you a bit about how it is that you came to be doing this sort of research, because I think it's fair to say that you started out a fair distance away from what you work on today. So you studied commerce law, and then you went and worked as an investment analyst.
Yeah.
And well, from my perspective, that's not the most obvious starting point for somebody who's ended up working on international criminal law and human rights. or is it? Was there something about that that led you to this, or was this a complete break and a decision to completely change what you're going to do with your life?
Yeah, like everything, it's probably a little bit of both if you can have a complete break, but also there was a continuity there. It's obviously, yeah, it's not an obvious leap. I guess the context is I became an investment analyst in that market peak just before the global financial crisis. And I'd been studying commerce law. I was very interested in the way global markets work. And I thought it would be, a really great way to get exposure to that and to apply what I thought were my mathematical skills, but also my research and communication sort of skills in this role that also made my family really proud and seemed quite exciting at the time. And I was mainly working on infrastructure private equity investments. And I do genuinely really enjoy the kind of problem solving and research side of that work, including little bits of work with our ultra high net worth clients, and including in Hong Kong and in Singapore. But equally, as I sort of did more and more transactions, it wasn't, for me personally, wasn't really intellectually fulfilling in the way that I think I might have, I kind of knew was always going to be the case actually, but it sort of became more and more evident. And as the global financial crisis started to unfold around me, it was just becoming harder and harder to work in an environment that I was just so sort of skeptical of a lot of what was going on in the world and also in the workplace. So yeah, I mean, when work was sort of suggesting that maybe I'd go and do an MBA or something, and instead I decided to start a master's, and I started a master's in international law and international relations, actually, to try and kind of make sense, I think, of a lot of what was going around me at work. And once I started studying though in that field, that was kind of it. I think a lot of things just fell into place. I was still working full time at that point, sort of as I was studying. And it did sort of alter things. And so then I was lucky enough to do an internship actually with DFAT, with Australia's mission to the UN, the Human Rights Council in Geneva. So I left that job, did some traveling. And when I got back, I just knew, I wanted to do something different in law, ideally international law. And actually, I volunteered at a conference and I did a bit of networking, and I was lucky enough to come across Professor Sarah Williams, and she and also Louise Chappell. They were working on a couple of Australian Research Council grants, and they needed someone to do research on the extraordinary chambers in the Courts of Cambodia. And so I jumped at that opportunity, and kind of everything went from there. And I was also doing some volunteering at a women's community legal centre that provides advice to women. I'm still on the board of that centre actually. And so a lot of things kind of coalesced and basically just gathered pace from there. So
yeah, wow. I mean, that's, yeah. And again, as with last week, a great story about sort of, trying out new things, and then opportunities come along and being able to sort of embrace new opportunities and sort of head in a new direction.
Very lucky, I think, too.
Yeah. And so you ended up working on these two really great ARC discovery projects. And then you decided to do a PhD at around the same sort of time, I gather. Yeah. And so why the PhD? Why the sort of going sort of, all in on the academic side, if you like?
Yeah, it honestly just seemed like the most natural and obvious thing to do. I've been thinking about it while I've been sort of traveling a lot. And, I perceived that this was a complete sort of redirection in my career. And I just knew that I would need training to do that. Basically. And I had that opportunity, and I was really, strongly encouraged and lucky to have the mentors that I had as well that helped me make that decision. Yeah.
Yeah. Yeah. I mean, and you've certainly, it seems, benefited from some really, really great people that you were able to work with, from the very, very beginning. So
yeah.
Your PhD, I don't want to talk too much about it because I want to sort of get to the book, but the PhD was focused on international criminal law in Southeast Asia.
Yeah.
And what I'm interested, particularly for the context of this conversation, is what inspired the Southeast Asian focus? Had you studied much of Asia before or spent a lot of time there? Like, what inspired that?
Yeah, so I am not an Asia specialist. I'm very, really conscious of that, particularly now. I think maybe I was a bit oblivious, honestly, when I set out. I mean, I'd studied Indonesian at school, and I was actually studying it at the time. So I had, had an interest and all that kind of thing. I'd done some travel, all those normal things. But I actually set out when I was planning the PhD, wanting to do something on international criminal law, and I wanted to do something regional. I was, and partly this probably came from that experience working in the financial industry, but I was really interested in the sort of domination of the International Criminal Court at the time in discussions about international criminal law in our region. There'd just been a conference on that theme at UNSW. And so I actually started out with a proposal to look at engagement with international criminal law across the whole Asia Pacific, which
was a small project,
obviously, but involved me using my finance skills to do these enormous spreadsheets of like every country, did the Asia Pacific's treaty ratifications, different domestic laws relating to international criminal law and humanitarian law, engagement with different mechanisms and that kind of thing. And I thought I'd probably look at Australia and something else. But it just became clear that, if I wanted to look at approaches to international criminal law beyond, as well as, with engagement with the International Criminal Court, and a range of different approaches that involve domestic legislation, so it was going to be a legal PhD, so domestic legislation and mechanisms, then it just made sense to focus on the region that was then, and maybe it still is, most maligned for not engaging with the International Criminal Court, which was Southeast Asia. So it actually came about through that mechanism. So yeah, it's funny now. I mean, it's not like I wouldn't encourage somebody to approach research in the region that way, but honestly now, not having existing expertise or being from the region, it honestly seems pretty sort of self-indulgent and crazy. But yeah, I think it's just important to be honest and transparent about that process.
Yeah, and these things very often take on like a really interesting evolution. Starting off with one particular project and a particular sort of scope in mind, and then it ends up being, something quite different. And there is something really nice about hearing about, that evolution along the way and how people made those decisions as they were conducting their research and things. So the book is based on the PhD, but I can absolutely attest to the amount of work that went into transforming it into a book. For those of you who don't know, I had the privilege of being able to read and comment on some of the chapters as they were being revised. And I can say this is a really good example of how successfully to turn a PhD into a book. So, they're quite sort of different beast. It doesn't read like a PhD in any way anymore. It's it's much more engaging and far less sort of formulaic than you'd expect a PhD to be. And the book examines how states in Southeast Asia have adapted approaches to prosecuting international crimes. It looks at 4 cases in the region: Cambodia, the Philippines, Indonesia, and Myanmar. And one of the things that I think is really, really striking about it is just how different these cases are. That, we put them together in Southeast Asia, but actually they are so different in so many really interesting and important ways. You've got Cambodia, which has the extraordinary chambers in the Courts of Cambodia, which was established to prosecute crimes during the Khmer Rouge period. We've got Indonesia, and I want to come back and talk about Indonesia in a minute, because I think the Indonesian case is really, really fascinating. Philippines, which has had this really significant role in the development of global human rights norms from the 1960s, and all these processes and mechanisms, and yet right now seems to be having all sorts of issues dealing with international criminal law. And then, of course, we've got Myanmar, which is in the midst of a transition. And that must have been actually quite difficult to include because, of course, that case is moving. I mean, they're all moving all the time, but that one in particular, and that there was no engagement with the ICC yet at the time that you finished the manuscript, I don't think. So that's a bit tricky. But what I'm really interested in then is how you went about researching these 4 very different cases, and how do you go about doing fieldwork on something like this in these really challenging environments?
Yeah, absolutely. And they were chosen deliberately to sort of represent these different types of engagement, different types of legal frameworks and sort of responses to the norm, if you will, of international criminal justice. So I did a combination of things. With this book, I did a lot of document analysis using in vivo reading, arguments from civil society groups within and beyond the region, and international reports and all sorts of things, of course, as much reading as I could before sort of diving in. And then I did spend several months but sort of traveling between those countries and interviewing people, so some formal interviews and a lot of other discussions, and of course, you know, heaps of Skype calls and follow-up meetings. I would love to have done more. I guess that's one of the many challenges of doing regional research, is that, you know, life happens and the distance makes things difficult to do that. But yeah, so I was talking mostly to civil society representatives and officials working on these topics as well, lawyers. And I carried, you know, I don't know if you want the detail of it all, but I carried out semi-structured interviews. I did a lot of preparation for my interviews, but mostly just ended up listening to people's stories, which, you know, revealed more than anything. I think, but you mentioned the challenges. Yeah, so the challenges I was really conscious of involved the potential security risks. I was really aware of the kind of ethical and elements of talking about these sensitive topics in some places at those times. And I guess also just logistical issues. Ones that I actually wanted to mention, so I'm glad you brought it up, that I was sort of less immediately aware of, but were actually really important and difficult, were just learning to do that kind of research, learning to listen, learning to not bring my own assumptions into the interviews, which I learned the hard way, I think, a few times. So cultural awareness, probably as part of that too, and just the process of fieldwork being, you know, can be actually also quite lonely, which I've kind of recalled recently in a self-isolation time. You know, and you're doing these sort of really sort of extractive feeling interviews, and then going back to your hotel where there might be other kind of tourists in this particular field and subject matter as well. You know, just I was very aware of the kind of, yeah, extractive and kind of almost neo-colonial part of that sort of research, which I think was just not something I really expected necessarily going in, but I think for people doing research in the region, it's just helpful to be cognizant of, you know.
Yeah, absolutely. Absolutely. So one of the things that you mentioned earlier is to do with this idea, you know, part of the genesis of the project, that we very, very quickly say, oh, well, you know, Asia in particular, you know, terrible when it comes to the acceptance of international criminal law and international human rights norms. We know that, you know, the region has, you know, as a region, the lowest level of membership of the ICC, and you know, Southeast Asia is not much better. And we could list 1,000,001 arguments as to why we very, very quickly and easily say, oh, well, you know, norm resistors, not particularly interested in international human rights, and so on. But that's really not the story that you tell in this. So, yeah, I'd really love you to elaborate a bit more on how it is that, you know, doing this research has really shown that those assumptions aren't necessarily right.
Yeah, I think that's right. I mean, part of it is right, you know, and I think that's an important thing to acknowledge, that that account of resistance does have, you know, truth to it. But I also, you know, when this really came about through talking to people, it is firstly quite state-centric in a sense. Like, I don't think it does justice to the, you know, incredible energy and creativity and flexibility of the people working on this issue in the region, and their sort of, you know, endurance and also ability to kind of quite nimbly adjust to the changing political dynamics and contexts in their various situations. And I guess I'm talking about activists, but not even just activists, but there are also people within administrations sort of quietly or less quietly working on these topics as well. So I wanted to sort of try and open up that part of the discussion and be a bit less sort of binary about it. And then even looking at the states, you know, from a legal perspective, there are these laws and these mechanisms, and they may have their faults and their problems, but you know, it's kind of the awkward truth of, if you think about the norm of international criminal justice involving states wanting them to adopt domestic laws and implement them as part of that norm acceptance process. Well, actually, some of these states have done that, and that might not fulfill what the full aspect of the norm and what people might like, but they have done some of these things. So that story just seems like a little bit something that should be explored and revealed a little bit more, rather than just writing off a situation as one of, well, you're either kind of accepting the norm or completely rejecting it. But it's also not just like about pointing out the nuance and the complexity for the sake of it. I think, you know, that means that there's all this kind of experience and lessons that are being learned that everyone can learn from, that you're potentially missing out on if you don't sort of delve into that.
Yeah. I mean, and I think that speaks in a way, you know, to the Indonesia case that I you know, mentioned earlier. I think that's a really, really fascinating one. You know, like Indonesia is involved in the negotiations for the ICC, but it doesn't end up signing the Rome Statute. Yet, you know, this is a state that is not, you know, completely rejecting many of these norms. That has, you know, instruments in place, that has moved to actually adopt many, you know, elements of, you know, this normative framework. And I think that does raise some really, really interesting questions about whether we're expecting sort of, you know, full acceptance, you know, as our benchmark. And if we are, why we are seeing this sort of, you know, partial adoption, if you like. You know, why is a state like Indonesia basically accepting large parts of this but not going the whole way, if you like, and sort of, you know, signing up?
Yeah. And look, and I think it's a good example too of how, you know, real life doesn't follow the kind of linear constructive sort of pathway of Cambodia, say, you know, or even Australia, sign a treaty, adopt the legislation, implement it, internalise the norm or not. So what I'll try and do in the book is set out the different laws and mechanisms that there are, but also the kind of context within which they were developed and the kind of arguments that were surrounding them and form the context for them. So, for instance, in the case of Indonesia, it goes something like, you know, if you look at the arguments that are in the documents and the interviews about responding to international crimes in that country, where there's a history of colonialism, of selective post-World War II prosecutions, politicised, an emphasis on sovereignty, of military dominance, also ensuring the unity and diversity of the country, and also being a leading democracy in the region. And if you think about all of those things, then that approach makes a lot more sense, potentially. But also it also helps you to think about how that approach might change over time and some of the sort of complexities around that. So, I think that's just it's an example of a country that kind of confounds that more linear or traditional storyline that we might think of. And there's something interesting in that. Well, why is that? Why can you have a different approach to crimes in 1965 but still be looking at including new international crimes in the criminal code going forward? What does that actually mean? And, you know, if we have different approaches to different crimes or different time periods,
And I think one of the things that this really speaks to, one of sort of the bigger issues that's a massive theme in international relations, international law, human rights at the moment, is understanding how norms are, you know, developed, spread, diffused, you know, adapted, and so on. And I think, you know, one of the really great contributions of this book is adding some more, you know, to that debate, and to really start, you know, challenging a bit more this dichotomy that we accept, that there is no global local dichotomy. Like we've known that for some time, yet we fall back to it very, very easily and say, well, it's mostly one or the other, or, you know, we have a particular sort of hybrid part in the middle. But I think, you know, what you're talking about is about a far more complicated and nuanced way of seeing how these things interact, and actually questioning those categories themselves, to say, you know, what we understand as the local might not actually exist in that form. That might not be the reality on the ground.
Yeah, look, I think it's actually really difficult because practically, you know, I still use those terms in the book, and we
Yeah.
often still use them, and I just sort of try and qualify them initially and delve into it a little bit more in the latter chapters in particular. This challenge that we are talking about international norms and various ideas of what local is, but when you actually set out about doing this kind of research, it's quite obvious that that doesn't fit with reality, and I think a lot of us have come across that. Not just, you know, particular arguments, whether they're human rights arguments, whether they're local or international is not clear. Whether a particular actor represents a global or local voice is never really clear. And so it's just, it's a real challenge practically as well as I think theoretically for us. So it's sort of, and on the other hand, you know, these spatial classifications matter and they help in some ways because they show that a particular context of colonialism in a specific place, or that crimes happen in a specific place, or that a protest is deliberately chosen to happen in a particular place at a particular time, can make a difference in terms of the arguments that are produced. So, I mean, basically I draw on the work of a lot of others in sort of exploring this, but trying to use different examples to sort of show how and when we might think beyond those divisions might be useful to think about, but also to kind of keep them qualified in our mind and recognise where sometimes the division between local and global can be better understood as a division of power and of access to particular opportunities and forums. So do you have access to speak in The Hague versus somewhere else, or online, or to use a particular legal argument and not, or not, and that kind of thing. So I try and look at that a little bit in the book as well, and hopefully, yeah, give examples to illustrate that.
Yeah, and I think what I really enjoyed is sort of the tying of that into your work on civil society actors, and just how well and readily civil society actors really reveal all of those sort of sets of tensions and nuances, if you like, between sort of, you know, traversing those two categories, but actually not necessarily belonging to them, and so on.
Yeah, I think that's right, and that's part of the adaptive aspect of it. So you could be citing domestic laws and constitutions in priority over international laws, even when those laws are based on the international laws, responding to different political situations by targeting, you know, particular individuals known to have studied in a particular country or have a particular background,
Yeah.
you know, framing your arguments to represent ideas like sovereignty or military professionalism that seem important to those recipients, favouring different reparative mechanisms or truth-telling oral history approaches, depending on the kind of background again or understanding of a particular context. So all of those different things. Yeah.
Okay. Look, I've got some questions that are popping up here, so maybe we should have a bit of a look and see what people are asking. So I have a question here. Could you talk more about the rationale behind the different case study selection?
Yeah, I'd love to.
Great answer to that one. I've read
it. It's always I think it's a really difficult one. And I did actually try to apply criteria to this process, but in hindsight, it's interesting to review that actually. So I was really interested already in the idea of exploring socialization approaches. So the idea of ratifying a treaty and implementing it, and localization or adaptive type of approaches. So I wanted to have cases that were kind of most likely acceptors of international criminal justice at the socialization end, and least likely and kind of somewhere in the middle, maybe most likely for adaptive. And so it kind of went from there. So to do that, I was looking at, is the state party to the Rome Statute? Have they adopted domestic legislation to prosecute these specific crimes? Have they established specific mechanism, legal mechanisms to prosecute these crimes? And a range of different things. And it kind of went from there. And I mean, there's a lot more detail in the first chapter of the book actually to come about this. But, I recognised that, so I had Cambodia as, signed the treaty, got the law, done some prosecutions. And so already you can see that, well, that's a kind of a most likely case, but that was already a little bit problematic. But I recognised, for instance, that I could also have had Timor-Leste, for instance, and the reason I didn't choose that country was because I, instead, for other reasons, wanted to have Indonesia because it had a domestic mechanism in place, and so I wanted to have that diversity represented, for instance. But there are countries like Singapore, like Thailand, that I also really could potentially have fit within the framework. You know, people say, well, why didn't Thailand's a really good sort of least likely case, but actually at the time there was discussion about a referral to the International Criminal Court related to the red shirt protests, so it was actually not quite that clear. Yeah, so anyway, so basically I was trying to make sure I had a diversity of states that had none of those laws and none of that engagement, states that had all of them, and, you know, one or two that had different aspects of those in the middle. So that's how that came about. So Indonesia and the Philippines, I should say, were the ones kind of in the middle. Indonesia having a domestic mechanism, and the Philippines having law in place, and at the time having chosen to ratify their own statute, but not having actually prosecuted international crimes yet at that stage. I mean, but again, things changed so much. So would the same exercise today give you the same case studies? I don't know.
Yes, I mean, in talking about, you know, that change, another question here is it fair to say that Southeast Asia does not engage with ICC processes, and what are the reasons for that? And that in itself is a really interesting story from the last few years of how much things change and go back and forward with the Philippines and Malaysia in particular. So, yeah.
Really, yeah. Malaysia also would, you know, in hindsight would have been really interesting, but anyway.
Would have been really tricky.
Yeah,
that would have all happened at the time you were revising the manuscript, really. Of, you know,
I mean, and that did
ratify and then withdrawing, and
yeah, it did. There was a lot of updating going on towards the end there.
Yeah. So I've got a question here from Nadia, who's one of our PhD students, and she's saying that she's interested to hear more about how you, as a foreigner, did research on really sensitive issues in these countries, and she's, you know, sort of saying that from the perspective of having to do sensitive research herself in the case that she's looking at.
Yeah, so look, I think I'd be very happy to have a longer conversation with you, firstly, Nadia, about this. So there are particular security things definitely to keep in mind that I've thought about a lot, actually. I think the other thing is, you know, from a methodological perspective, thinking about the sorts of questions you ask and the way that they're worded. Also, there's kind of a cultural awareness part about understanding that sometimes people might just not talk about some things, and learning when to leave that and not. That was, again, I could talk about in more depth later. But I will say also that in a lot of cases, people actually really want to talk about these issues, maybe more so than you would think. And a lot of the precautions that you go to make things very anonymous and very careful are, you know, for various activists completely crazy, because they want to tell you the story. And so that there's also that aspect as well. And then that presents its own challenges, I think, is, you know, to think about. So I think there's just it's really about, on the one hand, planning and trying to think through what things might arise, but also being flexible and recognizing you'll probably never be quite totally prepared for all of the things that might happen. But it doesn't hurt to, better safe than sorry, to be as secure as you can.
Yeah, absolutely. I mean, that big security issue, and that the planning around who you're talking to and how you're doing it and what you're asking them. And then
data security.
Part of the interesting part of doing that is the fact that it's live, and that people are unpredictable, and they will tell you things that you weren't expecting, or, you know, these will unfold in all sorts of interesting ways that you might start, you know, getting information that you never knew that you wanted in the first place. So
yeah, look, and I actually think a lot of the emphasis beyond the International Criminal Court came about through those interviews, where for a lot of people it just wasn't that important to their day-to-day work. So and that at first was quite challenging to deal with, because, you know, it seemed to be quite central to my thesis, but actually in the end that was, you know, that was a result, you know, that was actually part of the findings, was that there's so much engagement going on well beyond that court and well beyond without that language, and that's the story, you know.
So I've got a question from Fufu here. Did you incorporate any discussion around formal and informal practices of domestic context?
So I'm going to take that maybe as a reference to sort of institutionalist approaches and formal and informal frameworks, maybe, for thinking about things only because I'm pretty sure that you adopt that theoretical approach for yourself. And it's interesting because I thought a lot about applying that kind of theoretical framework, actually, and I still use it when I talk about the book, you know, particularly the way that new arguments and instruments like the Rome Statute are still kind of nested in this historical context. And the way that you can have a new formal rules around how you should respond to violence, and that they might not be implemented again because of the informal rules that persist. So I didn't go down that route because I was very interested in the norm of international criminal justice initially, but I do think it's still productive, actually, and, you know, completely. Had I been more familiar maybe with that theoretical approach initially, I might have brought in more of that kind of historical institutionalism than I did. Yeah.
And Caitlin Byrne is asking that she wonders whether you looked at the role that ASEAN as either enabler, inhibitor of international criminal law principles and norms and processes in the region. So, you know, what's the role of ASEAN?
Great question. And I had actually a big chunk that came out of the book and the PhD about ASEAN. And because I think it's fascinating and continuing to unfold. And I know you and Wayne and Graham's been doing some work on this, and others, and particularly the role of AICHA, the ASEAN Intergovernmental Commission on Human Rights, and some of the sort of mechanisms that ASEAN has as potential arenas for discussing and adapting this norm, I think, are quite interesting. Partly the difficulty has been that there hasn't been a lot of explicit engagement with international criminal law from ASEAN. There were some early quotes around, generally kind of positive, around the court, but then there's been. I'm really interested in thinking about constructive engagement as a response to international atrocities and that kind of thing, but they've been less focused on legal mechanisms, which I guess is the focus of the book. And ASEAN doesn't really have that role in this space of encouraging states to adopt specific laws, for instance. But its role in relation to Myanmar, it has evolved over, it's very interesting historically, but also more recently has evolved a lot in that way. So I actually think, there's probably a lot more work there to be done. But I think it's people that work with ASEAN closely are better placed to do that research than I am.
Okay, great. Well, we are just about out of time. We've run slightly over, but I wanted, just before we finish, I wanted to ask you that sort of the what's next question. What's the next big research project? So we're all going to really enjoy this, and I'm sure it's going to do really, really very well. So please go and buy it, review it, cite it, everybody. It's well worth your time. But what's the next one going to be?
Okay, well, the first thing is I'm about to have a baby. So 37 weeks pregnant today. So I have to say that's my next, the next project. But look, I'm really interested now. So a part of a lot of the sort of reflecting on my own role as a researcher that's come out of this book is that I think I'm trying to find spaces where I think I can genuinely add value. And there are not that many people that have worked at investment banks on infrastructure projects that have done this kind of research and are interested in the international criminal law. There are some, but that's the direction I'm going in. I'm really interested in the role that infrastructure plays in relation to atrocities and violence, both as being proposed as a solution, infrastructure development as a solution to violence, but also as being very much involved often in the perpetration of atrocities. So I'm sort of starting down to look more and more about the role of infrastructure in atrocities, basically.
Great. So if we did this interview in sort of 2 years' time, I wouldn't be saying, oh, it's really strange that, you started in one position and you ended up somewhere different, that in fact all those little strands are sort of going to come together.
I think that's right. It probably sounds very different to say I'm going to do something on infrastructure, but actually, I think it's really a natural progression, bringing everything together, hopefully. Yeah, thank you.
Well, thank you for your time, and best of luck with the book. And we've really enjoyed having this conversation, and we'll continue on Twitter, I'm sure. And for everybody else who's listening in, next week I'm going to talk to Luis Cabrera about his new book, The Humble Cosmopolitan. And he has posed a really intriguing sort of conversation starter already, about this idea that a humble cosmopolitan is an oxymoron. So I'm really, really fascinated to find out why he thinks cosmopolitans aren't usually humble. So hope you can join me next week for that one. So thank you. Goodbye.
Thanks so much, everybody, and to all your comments as well. And hi. All of the people that we don't get to see.